Amendment perspective between, for instance, the people who attended Trump's speech, the people who marched on the Capitol, and the people who actually breached the security lines, entered the Capitol, and engaged in riotous mayhem. I think with our own eyes, we can draw those distinctions, and certainly the law draws distinctions. So what about the people who just attended the rally? Knowing maybe that there might be violence, certainly participating in a message which would call into question our government and our democracy. How about attending a political rally like that? Well, sure, that's completely protected. Political speech occupies what we call the highest rung in constitutional analysis, and participating and being a member of the audience, clearly protected speech. And no, I don't think any scholar or litigator would say differently. What about the people who were a little bit more interactive? So when Trump and the various speakers started spouting their political nonsense, and people in the crowd shouted back, you know, get Mike Pence, take back our country, march on the Capitol. What about the people who were a little bit more interactive there? Is that going to be protected speech? And I would have to say at that point, yes, that's still entirely protected. We used to analyze these things under a test called the clear and present danger test. That was something that we used early in the century. The leading case was Schenck versus United States. And that's kind of an outmoded way of looking at these things. So when those speakers were yelling back to the president and trying to get the crowd going, saying, you know, let's get Mike Pence, let's get those congressmen, they were, you know, riling up the crowd. And it was at least foreseeable that danger could result, and they were speaking against our government. But even under this outmoded test, they would not have met that standard, I don't think. And we don't use that test anymore. We've moved on to what we call the Brandenburg test, which I'm going to talk about a lot when we get to former President Trump. Also, what about more specific comments like get Mike Pence? Is that going to be actionable? Is that illegal? And I would say no. That's what we call rhetorical hyperbole. And it's also protected speech. A case on that is Watts versus United States, in which a young man was prosecuted for saying, if they ever make me carry a rifle, the first man I want to get in my sights is LBJ. So that's something that's contingent, it's not immediate, it's really rhetorical. That sort of thing is all protected speech. So what about the people that actually marched on the Capitol? Again, you know, there are some issues on the margin. Do they have a permit? Were they blocking access to streets or emergency vehicles? But by and large, that's going to be protected speech. We always think about our parks and our streets as what we call quintessential public forum. That's really where speech is meant to occur. You know, the Department of Transportation doesn't much like it because it's inconvenient. But in terms of First Amendment, that really is kind of core speech going on there. So marching to the Capitol, good to go. That's protected speech. Surrounding the Capitol, I think all protected. Breaching the security lines, that's where they had some problems. So the moment that they started going into the Capitol, fighting with the police, breaking windows, and actually engaging in insurrection, none of that's going to be protected speech. That kind of riotous behavior is simply conduct. And even though it bears a political message and it's got a political motivation, obviously, not protected speech. And we're going to have some interesting questions as this goes along to divide further amongst those insurrectionists between the people that were just violating federal law, most of it minor stuff, you know, being on property when you're not supposed to be. It's kind of like federal trespass. But what about the few that actually may have engaged in a conspiracy against our government? We'll talk about President Trump. He may be in that category. But certainly, it's a good question to ask about the people who broached our Capitol's security lines. Were they engaged in an actual conspiracy to overthrow our government? Because that's illegal. There's a statute called the Smith Act, which is 18 USC 2385, which says that advocating the violent overthrow of government is itself a crime. It's conspiracy. It appears that some of the insurrectionists will fit into that category. And I believe at least 3 of them have been charged criminally with violating the Smith Act or an equivalent statute. Those are, assuming the facts are there to warrant it, those are legitimate charges, and the First Amendment is not going to be a defense against it, because clearly the people, the First Amendment does draw lines. And when we get into the idea of actual acts which are violative of trespass, destroy federal property, hurt people, or advocate for the overthrow of government violently, those are not protected, and those people are in an awful lot of trouble. I wanted to just do an aside. It's an interesting comparison to look at the insurrectionists and compare it to the Black Lives Matter movement. I think there's some comparisons and some points of distinction. So we know, for instance, that the organizers of Black Lives Matter did not advocate for the destruction of property or hurting people, and by and large, not even obstruction, like occupying streets. Certainly, some of the members did. They may face some minor liability, but probably defensible. And then, of course, there were rioters who engaged in property crimes. And those are pretty easy lines to draw too. The rioters, obviously not protected speech, even though they're attending a political rally. But the rest of the participants, not just protected, but protected more obviously than many of the people who participated in the events of January 6th. So there's the political end of it, motivations, good people, bad people. The First Amendment is not concerned with any of that. It's just protected or not. And clearly on both with BLM and with the January 6th events, we can pigeonhole people into different categories. And that makes all the difference in terms of our political rights and also protection of the First Amendment, because we do vigorously protect all manner of speech. And Josh Hawley's might be a good example of speech we may not like, speech that was not socially useful, but is protected. So at least from my perspective, I saw 2 aspects of speech that are interesting to comment on. One is his, Black Lives Matter kind of white, Black Power fist bump to the insurrectionists, to the people attending Trump's rally. Is that protected speech? Is it speech at all? It is speech. It's what we call expressive conduct. And a case on that point that kind of established that, there are a couple of them, O'Brien versus United States, which involved burning of draft cards, Cohen versus California, a case where a guy went into a courthouse wearing a jacket that said "fuck the draft" on the back. Those are considered expressive speech. And Hawley's, I guess you'd say it, member of the tribe, go team go, political identification. It was not just a gesture. He wasn't like flipping people off, can just be a gesture, or it can be communicative. I'd have to say that that act by Hawley is going to tag him politically, but in terms of speech, entirely protected by the First Amendment. What about his participation in the votes to disallow the electoral count from Arizona and Pennsylvania? Also political, very controversial, entirely protected. And from 2 sources, actually, one of which I bet most of you never heard of. There's something in our Constitution called the Speech or Debate Clause that applies specifically and really only to congressmen and their minions, people who work for Congress. And that principle says it's to encourage absolute free debate and also to protect against political payback or political penalties. So when congressmen and senators are speaking on the floor of the Capitol, when they're engaged in political speech or advocating for legislation, anything remotely related to their jobs, they are about as absolutely protected as you can get under our Constitution. So Hawley, in advocating what some may see as taking apart our government, nonetheless, because that speech and debate occurred in Congress, that is entirely protected speech. Also protected by the First Amendment, you know, the good old political speech. So Hawley may eventually pay some political price for his advocacy, but certainly protected by the Constitution. The only exception in the speech or debate clause has to do in instances of treason. So did Hawley engage in treason? Possibly, probably not. It is conceivable that he engaged in a vast conspiracy with other senators, Cruz in particular, and President Trump, specifically knowing that unrest was coming, maybe with an intent to move on to martial law. I think that they're not going to develop those facts and they may not exist. But if they do, in that extremis, even the speech and debate clause would not protect Senator Hawley's activities. But I don't think we ever get near that point. Let's talk a little bit about Rudy Giuliani, who's funny if for no other reason is he's a really colorful character. So what's the First Amendment say about him? A lot, I think. So we know that he has that famous, by now infamous comment about trial by combat, that the crowd that attended the January 6th political rally is involved in trial by combat and suggests that that's a really good thing. Is that protected? Well, I think it probably is. As a matter of fact, I'm sure it is. So there are a couple little cases, little categories that might apply. One of them would be fighting words. That's the old Chaplinsky versus New Hampshire conception, which said basically if you called someone a son of a bitch to their face and they popped you in the nose, that you had it coming. So Giuliani's words were not fighting words because they were not directed to an individual. They were not personally insulting to someone standing in front of him. Also, most First Amendment practitioners really doubt whether fighting words has any real application to today's society. In part because our society is a bit coarsened. A lot of things that used to be fighting words, like calling someone a bastard, are pretty mild things these days. Also, we like to think that culturally we've evolved a little bit. And so sticks and stones is kind of the modern take of things, rather than you get a free pass because someone insulted you. So the doctrine has not been actually overruled, but it's kind of dead. In any event, Rudy's words would not have fit in that fighting words doctrine. Does he work under the Brandenburg test, the imminent incitement to lawless action? Well, I don't think so, because we look at words not just as to what was said, but in terms of context. So if we look at Rudy's speech, we see that when he talks about trial by combat, his voice is not elevated. He's not yelling. He's not exhorting the crowd. Also, it was part of a larger context. He was talking about voting irregularities and voting machines and how the president's been cheated out of his election. So in context, he's not actually directly advocating violence. If you take those words out of context, they're suspicious. But in context, I don't think we get anywhere near the incitement to violence. What about the fact that that these allegations of election fraud are the original fake news? At this point, we can just call them what they are, which are lies and fictions. We do live in a real world. We have to look at the facts. And there's an old adage, everyone's entitled to their own opinion. You're not entitled to your own facts. And if for nothing else, me as a litigator, I like to look at what courts say about things, because they are fact-finding entities. That's why we have them. And we all do know that many of these allegations went through the court system. Over 60 cases were adjudicated. And of course, they were thrown out in all instances. Interestingly, though, if you actually look at those case decisions, and if you actually look at the briefs that were filed in them, as I have, it's interesting that the things that Rudy and his cohorts talk about at their various press conferences, at various landscaping entities, they never mention those things in court filings. You don't see any mentions about Dominion election balloting. You don't see, they're hyper-technical issues. And actually, in most of the cases, there's not even an allegation that a vote was changed or that someone was allowed to vote that wasn't supposed to. There are a minority of those cases, but the overwhelming majority of them had to do with very hyper-technical legal issues, all of which were denied by the courts ultimately. So can Rudy get up in a public stage and just lie about something? And generally speaking, the answer is yeah. And in fact, in many contexts, there's actually a First Amendment right to lie. And the seminal case there is called Alvarez versus US. It involved a fellow who I think was running for Congress, maybe as his state legislature, and he claimed to have won the Medal of Honor. And that was a fiction. He did not. He lied about it. And he was prosecuted under a federal crime that says you're not allowed to lie about military decorations. And the Supreme Court said, no, unless the lie is involved in some sort of other wrongdoing. So for instance, a criminal conspiracy. Are you lying to promote a criminal conspiracy? Well, that can be a criminal act. Or are you lying as part of defamation? That can be a civil wrong. But merely lying, unless it's directly, immediately linked to some other wrongdoing, is typically protected speech. And so the fact that Rudy obviously lied in public, he gets to do that. There are some limitations. He is facing some fallout for his statements, both on January 6th and through the extended campaign. So what are those risks? Well, he's probably going to get disbarred. So in his particular circumstances, that's a lesser concern than it would be, for instance, if he were a member of the Florida bar, because he practices from New York. New York has a voluntary private bar association. And so the rights that adhere to a private social organization are not as stringent as an organization like the Florida bar that ultimately is an official regulatory arm of the state. In Florida, he could still be disbarred, I think, because he did make some misrepresentations in court, and he certainly made many representations in public about court proceedings. And interestingly, attorneys actually have much less in the way of First Amendment protection than the average citizen. And that's because we're licensed professionals. We owe a duty of candor to the courts, and we're not allowed to denigrate courts in the public realm. Now, there's a lot of leeway there. Courts only act on the extremes, but I think that Rudy could face some real problems, and whatever bar might regulate him. It's also possible that we may see some action through courts taking their own sanctions, like Rule 11 violations. When you file a frivolous filing with the court, you can be sanctioned monetarily for that. And also has been in the news very, very recently is Rudy and many of his cohorts, including some at Fox News and including at least one of Trump's other attorneys, are being sued for defamation by Smartmatic and by Dominion, which are the election voting machine and software companies. So what do we think about that? Rudy and his friends made a lot of comments suggesting that those voting machines disenfranchised people. They counted only votes for Biden. They were associated with Venezuela's long dead socialist leader. Crazy crap. So are you allowed to say crazy crap in the world? To some extent, yes. As we talked about, like with Alvarez, you can lie about a lot of things. In the political realm, you can tell a lot of political untruths. But what if you say a fact that is falsifiable? In other words, it's not a statement of opinion. It's not a political belief, but it's a statement. Did Dominion devise machines that were calculated to make Trump lose the election? That's a yes or a no. That's a binary decision. It's provable or disprovable. Those sort of facts can be subject to defamation. And also, unlike Trump, for instance, who usually talks about some people are saying or, some people in Congress. In this case, Rudy and his cohorts targeted particular private people and private organizations. Are they subject to liability? And the answer is yes, they are. Now, it's a very heightened standard because the First Amendment talks about defamation as well. The New York Times versus Sullivan case being the lead example, and a case that a very good friend of mine litigated in the Supreme Court, Gertz versus Welch, which had to do with public characters. So in this case, the public character it's not directed to the speaker, which would be Rudy. It's directed to the subject of the attack, which in this case is Dominion and Smartmatic. So those are not really household words, but in terms of the people that Dominion deals with on a daily basis, which are election supervisors, the people that actually buy their machines, or for Smartmatic, the people who buy their software, they may lose business as a result of that, either through political pressure brought to bear to those election supervisors, or because Giuliani has convinced those supervisors that Dominion really does create bad machines. So Dominion, I would say, is in the public realm, and so it is going to be any case against Giuliani is going to be held to a higher standard. You have to show constitutional malice, which in this case means not just negligence, but intentional or reckless behavior, that you really knew that what you were lying about was in fact untrue. So in my own estimation, I do a fair amount of defamation work out in the real world, mostly for defendants, but occasionally plaintiffs' work. I think Rudy's got some real vulnerability here. And I would not be surprised if there's at one day a verdict against these guys. Because again, speech has consequences, even in the public realm, about matters of public concern. So that brings us to our former dear leader, Donald Trump. What can we say about his actions on January 6th? Not politically, because we all have our viewpoint about that, but what is the First Amendment and the law and the court system, and in particular his impeachment? How is that all bound up with what Trump said? So his words all are around this fight like hell theme, right? So on the day of January 6th, did he say or do things that would meet the Brandenburg test, which is imminent incitement to lawless action? So that's something that's a little bit beyond offensive speech or speech that riles up a crowd. And so, there are speakers that rile up a crowd, and we always want to avoid Hitler analogies, right? Because that gets us into Godwin's law about the internet, that if a chat goes on long enough, people always end up making comparisons to Hitler and Nazis. So we don't want to go down that realm. But we can look at what contemporaries believe that the speech was about. So I'll do two quick quotes. These are by people of Trump's own political party, prominent Republicans. One is a fellow named John Katko, who's a representative from New York, and this is his view of what Trump had to say on the 6th. He said, "It cannot be ignored that President Trump encouraged this insurrection, both on social media ahead of January 6th and in his speech that day. By deliberately promoting baseless theories suggesting the election was somehow stolen, the president created a combustible environment of misinformation, disenfranchisement, and division. When this manifested in violent acts on January 6th, he refused to promptly and forcefully call it off, putting countless lives in danger." And then we have the words that have been widely reported from that bastion of progressive activism, Liz Cheney, who had to say, "There has never been a greater betrayal by a president of the United States of his oath and his oath to the Constitution." So clearly Trump had some things to say that were politically divisive and offensive, bad for our country, embarrassing, whatever you might say. But did he actually incite people to violence? That's the question that the courts would ask. And that is the dividing line between protected and unprotected speech. So that gets us to Brandenburg versus Ohio, which is still the prevailing standard on this issue. So this is what Brandenburg says. The constitutional guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or of the law of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. So Trump can certainly say the election's been stolen. That's a lie. He can certainly say people are conspiring in government against him. That's a lie. He can say things like Pence has the ability to nullify the electoral counting. That's a lie. And he can also say we should march on the Capitol. But he should be saying that march has to be peaceful and orderly. That's not exactly what he said. Trump really is the master, though, of couching his words in code. And we have to look at context. So in my estimation, the things he actually said on the 6th are not incitement to imminent lawless action. I think they're about as close as you can get without heading over that line. But it's a very close question. And part of it is context. So for one thing, it's not just words that are said. So if you look at a transcript of any speech, it's a lot different. The experience of it is so much different than being there and hearing that speech. The emotions, the body language, all that stuff that goes along with oration. So I know, for instance, when I do an oral argument, sometimes I think I did a pretty good job, sometimes not. But when I read my transcript, it's always a different experience. And also, I always come across like a moron when I read my transcripts. So with Trump, it's not just what he said, it's how he said it. And the way he says it and the pacing and his body language, and also the codes that he uses with the people that follow him. But it also is not just the words he said on that day, because we know the context in which he spoke, which is months and months of disinformation about how mail-in ballots are illegal. They encourage fraud. In minority cities, we're going to see fraud because we can't trust the count in places like Detroit and Philadelphia. So that was going on months ahead of the election. And then we know all about the social media posts. We know about his post that says, come to Washington on the 6th, it's going to be wild. So Trump's actual words on January 6th were not in a vacuum. And so that makes it in part why, from a First Amendment perspective, it's really difficult to draw that line. And again, my own estimation as a litigator is, and not a fan of the former president, is he came up to that line but didn't go over. So I don't think he can be prosecuted for what he said, but a very close question. And I'll give you an example, a real life comparator that shows you how close these questions can be. So there were people who were prosecuted for war crimes and genocide in Rwanda that didn't participate in war crimes or genocide. They didn't hurt anybody directly. Instead, they sat in a radio booth and issued threats and communications and promoted the ongoing genocide, and went so far as to call out actual people and to say where Tutsis and Hutus were hiding, so that members of the who actually were killing people could find them and dismember them. So these people were convicted of genocide based on words alone. And in a US context, also, that would be incitement. And that's the kind of thing that we're looking for under the Brandenburg test. We also look at precedent, and in fact, arguments under Brandenburg, cases under Brandenburg are vanishingly rare. I did some quick research for today's presentation. I think I found 2 or 3 11th Circuit cases, 1 case out of our federal district court in the Northern District. So this idea of incitement as being a basis to prosecute someone, it's tough to do under our First Amendment, and it ought to be tough if we're going to value our First Amendment protections. So I don't think Trump crossed that line. So what kind of liability does he face? Are there any future consequences? Well, he's got impeached, right? Let's look at that a little bit. So impeachment is ultimately a political question. And we should ask the question, does the First Amendment apply to impeachment? And the short answer is no. There's a brilliant discussion of this, by the way, in the trial brief that was filed by the House managers. It's widely available online. It runs to 80 pages. But in terms of a political document and a legal document and a constitutional document, I can tell you it is utterly fascinating. For me, it was a page turner. So they explain why the First Amendment just doesn't apply to impeachment at all, primarily because it's not really government punishing a private citizen is kind of the shorthand of it. We know that Trump has raised in his own filings a defense of the First Amendment, that it was protected political speech. And so the question to ask from my perspective, is that true? And I think again, that's a pretty easy answer, and it is no. The First Amendment is not going to be a defense to Trump's impeachment. It would actually not be an impediment to civil prosecution or a civil suit, a tort suit either, for various reasons. One of them involving this case called Garcetti versus Cervellos, a Supreme Court case, which reminds us that government employees, of which Trump was the foremost, actually are entitled to far less First Amendment protections than you all as private citizens. And that's because government has an interest in maintaining its own message and maintaining its own orderly processes. So when you have people who are in public office speaking about even matters of great public concern, there's a balancing test called the Pickering balancing test that applies. And Trump comes out on the wrong side of that balancing test because although he may have been not inciting people to violence, he was basically advocating for the overthrow of our government. He was doing it in a very irresponsible way, and he was lying about it. So in terms of the First Amendment, I don't think he gets First Amendment protection in terms of civil disadvantages, including impeachment. This is something that I have not actually seen raised in Trump's defense, but there's something called the government speech doctrine. And basically what it boils down to is the First Amendment does not apply to government speech. So, does Trump get to take advantage of that? And the answer is no, again, for a number of reasons. One is because he was not speaking on behalf of government. It was not a government message. In fact, the message was really to advocate for the overthrow of our government processes. And so government speech doctrine is not going to protect Trump at all, either impeachment or out in the real world. So what can happen to him? We talked a little bit about defamation. I think it's pretty clear that Rudy Giuliani's got some exposure there. Trump probably does not, because as his usual technique, he did not call out individual people for his comments, with the exception of Mike Pence. Could Mike Pence sue Trump for defamation? I think he probably could, but of course, again, this is me speaking, having a political opinion, not a legal one. Mike Pence did not display a whole lot of backbone. He's not going to be suing Trump, even though probably he could legally. And then the other question, which I find a little troublesome under modern precedent, is can Trump be sued civilly for inciting that mob? So even though it's not a crime, probably, even though I think the First Amendment does largely protect most aspects of his speech, the question could be, for instance, the heirs of the police officer, the Capitol police officer who was murdered. Could they sue Trump and say that he's responsible ultimately for sending that mob like a cannon directed to our legislature? Under present case law, the answer is maybe. And that concerns me because I think the answer should be absolutely not. We know Trump didn't personally lead the march, maybe a little bit too smart or cowardly, depending on your perspective, but he did not lead the march himself. He just talked about it. But there's a case out there called McKesson versus Doe. It's a Fifth Circuit case at the moment, although the Supreme Court had a piece of it. Most recently, just in November, the Supreme Court vacated this decision and sent it back for further determinations as to what Louisiana law has to say about this. But here are the facts just briefly. It involved a Black Lives Matter protest in which a police officer was injured. And the context of the injury was he was hit by a heavy object, I think thrown from a roadway, or the officer was trying to control the roadways that were being overtaken by the Black Lives Matter protesters. The long and short of it is this police officer who was injured in the course of his duties has sued a speaker, a fiery speaker, and the organizers of this particular political protest, saying that some aspects of their speech were negligent. In particular, the idea that they should occupy the streets, that it is foreseeable that by doing so, that they would cause chaos, that police officers would have to respond, and that officers could be injured. And so at the moment, this is a live case. And if it ever becomes an established precedent, I could see people who were injured in the course of the Capitol insurrection suing Trump. It's possible. That makes me as a First Amendment litigator extremely leery. And I think it is a threat to the idea of fiery political debate, which has its uses in our society. So I've run a little longer than I had intended. I want to close out with just some real quick comments about Section 230 immunity and the Twitterverse. So as we know, Twitter has now banned Trump. Facebook has as well. At some level, I think that's a nice thing. I don't have to hear about the tweets and the enormous social disruption it causes. But it should cause concern for us and make us think twice, because there's no question that Donald Trump is the spokesman for a large section of our society. He's a political speaker, and until a couple of days ago, he used to be our president. So what he says matters. It's something it's a message a lot of people in the United States want to hear, and it's a message which the First Amendment would say is largely protected. So can Trump sue Twitter for kicking him off? Under the First Amendment, that's easy. He cannot. And the reason being is the First Amendment applies only to government action. And of course, Twitter is a private company. There's some that argue that it's essentially a public utility or an arm of government because government protects it. And I can tell you those are just nonsense arguments from a legal perspective anyway. Can Trump sue them under his contract with them, just like any other citizen can sue? And the answer to that is yes, but good luck. So the attorneys that work for Twitter and Facebook are bright fellas. They draft these terms of service in a way that gives the services the maximum discretion, and no one ever wins them. So apparently there's now a review process that Twitter and some of these businesses have set up to review their decisions. That is solely an internal process. The law has almost nothing to say about it. And basically they're just going to decide for themselves as private citizens whether they should reinstate Trump or not. So I'm glad that review process exists. It's not an excuse for all of society's concerns. It's not a magic cure-all, but maybe at least it takes it out of Zuckerberg's hands and puts it into a wider venue. So that's always a good thing. Section 230 immunity, my view is it's a good thing. The First Amendment probably compels that immunity in any respect. And what it basically says is that ISPs that provide a service, the link between individual citizens and the broader internet, are protected because they're not posting their own content. They're posting what other people have to say. And the Section 230 allows them to make some value content-based decisions, which government would not be allowed to, but the private citizens are, and they can make those decisions without fear of immunity. there's some real questions about monopolistic practices and the obvious societal harm that having these megalith social media companies out there, they pose some real threats to society and some real concerns as to whether they can actually squelch debate, like has happened with Donald Trump. But those are primarily not things that are going to be decided under the First Amendment, because the First Amendment is going to protect that sort of behavior. And so if we as a society are going to do something about those social media giants, it's going to be through economic legislation and things like anti-monopoly suits. So that's something, stay tuned, because it's in the news every day. It makes a very big difference in our everyday lives. And it is going to impact our core First Amendment values. And with that, thank you for your attention. It's been a blast for me. And if y'all have questions, I'd love to entertain them.
Gary, this is Jay Whitehead. I really enjoyed your talk very much. I thought I knew something about the First Amendment, and clearly I don't. It's much more complex than I imagined with all the precedents and stuff. But what I'm concerned about is the impact of the internet in making insular communities of public opinion and stuff like that. It's affected everybody's work, and I'm sort of wondering, has it affected the law? We hear about Republican judges and Democratic judges in Federalist Society and all that. These people can stay within their own opinion spheres. Has there been any impact that you would care to talk about?
I would say no. So the one thing about the First Amendment, I should say, the reason I love this practice so much is it literally changes every day, and sometimes on a pretty fundamental level. And so for an attorney, you know, I'm learning and I'm researching, and the evolution of the law to me is fascinating, and it keeps the practice young. So there's always something to learn about the First Amendment, and I am not the master by any means. In terms of, but the thing about the First Amendment, it is relatively unique in the world. Canada, for instance, has a different approach. England has a very different approach, and the continent, the EU, has still a very different approach. They're much more, the rest of the world would tolerate a lot of regulation that just doesn't fly here in the States. Mm-hmm. But in terms of the social threat and the way that couple things, the way that it actually narrows our views, doesn't expand them as it should, and the ability to do the big lie, as we saw in this election, that's a real social concern. So the First Amendment's not going to change, and the precedent is not going to have a direct effect on these vital social questions, I don't think. The law, you know, in terms of legislation, is always like 10 years behind under the best of circumstances. We've had bipartisan gridlock now for 15 or 20 years. And so the ability to even begin to address these very complex issues, it's just a daunting task, and I've got no answers about that whatsoever.
Thank you.
Okay, how Shirley?
Gary, I was prepared to think that I'd love for you to defend me, but I don't like the way you take care of the other people who speak what I don't like. I mean, that's a given for the way we feel. But if they can document Trump's reaction as this rioting was going on in the Capitol, does that change the impression of what he was inciting?
Yes. And so I'll speak as a little on the political side. So I'm not a believer in conspiracies particularly, because, you know, it requires secrecy, and the more people you have involved, the more likely it's going to spill. I actually am leaning in favor of the idea there was an actual conspiracy here. And I tend to think that Trump intended to incite this riot, and he may have intended to invoke martial law, and then, you know, just take matters into his own hands. I don't know that that's true, and we may never find out for sure. If it is true, that would actually be a conspiracy against government. and that's not First Amendment protected. It's a criminal act. It's also treason. And so I'm not taking that off the table. I think that could have happened here. But we're always dancing this fine line with the First Amendment. We have decided now for hundreds of years that this is the best way to order a society where we have the marketplace of ideas. Again, the fragmentation of that market poses a challenge for social theory. But in terms of our societal commitment to free speech, it's been there for a couple hundred years. And I think it's held us in good stead. I like our model better than the rest of the world. But one of the consequences of the First Amendment is sometimes truth does not prevail. And sometimes we have to hear really ugly speech. So my own view of things, I'm on the progressive side. Overwhelmingly, I tend to represent progressive interests. But there are times when the First Amendment needs to be protected. And to me, that's its own thing. And it's also divorced from political content. It doesn't matter if you're a good guy or a bad guy, the First Amendment protects us all. There are limits, and as it's been said, the First Amendment is not a suicide pact. And if in fact it turns out that Trump or insurrectionists or people like Josh Hawley and Cruz actually engaged in a conspiracy to overthrow our government, they can be prosecuted for that, and that would be some interesting news.
Thank you.
Okay, Jane?
Yes, thank you. It's a very interesting talk. I was wondered about when you were talking about insurrectionists. I was wondering about apparently there's evidence that many of the, or at least some of the insurrectionists were active duty military and active duty police, and I wondered if the decisions were different or the law was different for them.
It is actually different for them, but on a dividing line. So the people who actually crossed onto Capitol grounds and did so as part of a conspiracy or even just spur of the moment, those folks are going to be subject to criminal liability. They are not protected by the First Amendment. And it doesn't matter if you're active duty or not, the same criminal law applies, same standard. But for people who, for instance, may have attended Trump's rally and maybe marched from the rally to the Capitol, if they were active duty military or police, they could probably be discharged under this Garcetti standard, which again, let's assume that what they were engaged in was actual speech. So for instance, participating in a march from Trump's rally to the Capitol, that's probably speech-oriented, protected. For most of us, but for active duty people, maybe not. And particularly if they were identifiable, if they wore some element of their uniform, their name badge, anything like that, their unit patch. Under the Garcetti case, as government employees, they can be discharged for that. So what they're going to be facing for that political speech that would be protected for me or you, they won't be prosecuted for it. They're not going to be fined for it, but they can be fired. They can be terminated. So yeah, they face a somewhat different standard. It's one as a First Amendment litigator, I'm actually a bit uncomfortable with. I'm not a fan of the Garcetti case, but that is the law, established precedent. Yeah.
Thanks. Rick and then Don. Rick?
Yeah, I appreciate the way that you differentiated the rights of protesters and the rights of the insurrectionists, to be short in the just way that we talk about them. But I think that we're seeing nationally and in Florida an effort to show that the current laws that we have are insufficient for taking care of people who are like the insurrectionists. And this might have a chilling effect on those who are trying to organize demonstrations Um,
Yeah, there's a Florida bill.
Could you address the potential impact of like Florida's HB1 and for organizers of demonstrations who fear that there might be people who intend violence among them?
This is the good stuff. So I hope to be litigating some of these issues sometime. There are like two aspects of what's going on with the Florida legislature. One of them, I've actually read the bill, and that has to do with efforts to punish Twitter and Facebook and social media companies to regulate them for taking down, for deplatforming Trump. So deplatform is a noun and a verb these days. And then there's the other bill that DeSantis is pushing, which would have enhanced criminal penalties for being involved in political demonstrations that then have some violent component, particularly like occupying roadways. From my view, those are misguided. I think they are terrible social policy, but also almost certainly unconstitutional. So on the punishing Twitter, there are all sorts of constitutional issues there, starting with First Amendment retaliation, which is retaliating for content-based reasons, specifically to punish Twitter for taking Trump off the platform. That sort of thing is a no-no under the First Amendment. Also, there are some other very sophisticated things that we don't hear about. Dormant commerce clause, for instance, the idea that Florida can't set commercial standards for other states or affect people who are in other states doing an international or interstate trade. There are all sorts of interesting constitutional issues on that end. And then Governor DeSantis's idea of punishing protesters, that's just a non-starter under the First Amendment. There's a narrower question, which is, can we have an enhanced penalty for someone who is not engaging in speech, but is actually rioting? And by that, I mean, not being unruly and shouting and yelling at the police, but doing things like breaking windows and robbing and putting graffiti on a federal courthouse. That's conduct and it's criminal. And so can you enhance those penalties? There's precedent that says yes. For instance, we have hate speech enhancements. Again, from my perspective as a First Amendment litigator and advocate, I think that those are questionable, but most of them have survived scrutiny eventually. And enhanced penalties in Florida also could be a thing, but it's something that I certainly would litigate against, and we'll have to see. So one thing, again, politics informs everything. We have a unitary Republican control in Florida and have for a very long time. And so the question is, can these things be passed as a political matter? And unfortunately, probably they can. One thing that I always harp about to people who will listen, so you're sort of like a captive audience, this idea that politicians should take their oaths more seriously. And so many times I see politicians, excuse me, enact laws that they know are unconstitutional, but that they see as a public good. And that should be a non-starter for politicians. And the higher you are, the more attention you ought to pay to your oath, it seems to me. And so just because you think things are politically wise or even socially useful, the Constitution is supposed to be a check on those people, those politicians. And if it's not, then one, we can vote them out of office, and two, people can hire me to sue them.
Okay, Don or Tina, and you have to unmute yourself. And then anybody else who has a question, you can electronically raise your hand. Okay, Don.
Hear us? Both of us have a question. My question it deals with what the Senate can do in terms of precedent. Precedent doesn't seem to, or any kind of stuff going on, they seem to have their own rules and they can do anything. So any argument that's made has to be on what level? to actually get people to say, oh, that's compelling, he should be impeached, or that's compelling, he shouldn't. Could you comment, please?
Sure. So again, I'd encourage you to read the House Manager's trial brief because it's a genius piece of writing. Other than answering these really good questions, it's actually just well written. So if you're a fan of prose, it is a page turner.
Well,
So impeachment is fundamentally a political decision. And it's interesting because the House managers do talk in terms of precedent, just like an attorney would to a court. And for instance, on this initial question of whether you can impeach someone who no longer holds office, they point to what we call statutory interpretation, what I would call that, which is what does the Constitution say? And also legislative history. What did the founding fathers say? What did the Federalist Papers say? So they talk about that just like an attorney would. And they also talk about some precedent where the Senate has actually held impeachment trials on people removed from office and what they've done about it. And so if you were looking at it from a precedential standpoint, it is a very easy decision. And if you look at it from constitutional construction perspective, very easy decision. And that is that yes, Trump can stand impeachment and he can be disqualified from office. That in terms of legal jurisdiction, that definitely lies in the Senate. It does concern me, though, that, for instance, they just took that vote on whether or not to dismiss the charges for lack of jurisdiction. So in a more, I don't know, civilized time, perhaps, in a time where oaths meant a little bit more, people would do things like vote against their interests because the Constitution speaks a larger truth, or because you took an oath and you have to follow the Constitution, and that's what you're going to do. For instance, like what Mike Pence recently did, to his credit. You would like to think that many senators who ultimately are already decided that they're going to acquit Trump would nonetheless have voted in favor of jurisdiction because it does set a precedent. And there is going to come a time in our future, maybe not a president, maybe it's just going to be a judge, or a Secretary of Defense or something, someone who is going to resign in order to avoid consequences, but we're going to want to punish by not letting them back into the public realm, or we're going to want to take away their pension, which is, an economic sanction. And so for senators to vote that they don't have that jurisdiction as a matter of precedent is concerning, and it's wrong. What those people should have done if they took their oath seriously, and what they should have done if they respected themselves as senators, is vote that they do have jurisdiction and then vote to acquit the man. That would have been the preferable thing. So the short answer to your question is there is a precedent, a body of, you could call it case law, but it really is ultimately a political decision. And also it never ends up in court. There's no aspect of the impeachment that will ever end up in court. It's non-justiciable, is our legal term. And sole jurisdiction over these questions is lodged in Congress.
Very good. Last question, Abe Goldman. Unmute yourself.
Thank you. Yes, thank you. Thanks, Gary. That was a fascinating talk. We're aside from what's happening in Congress, we're seeing a real proliferation of groups that are pretty explicitly advocating the violent overthrow of the government. Mm-hmm. And I wonder, is there a point at which that advocacy actually, violates or goes beyond First Amendment protection? Or do you actually have to engage in violent activity?
Under Brandenburg, there is a line to be drawn, which is that imminent incitement. So as long as you're just talking a good game, right, that's not actionable. It's not a criminal wrong, fully protected by the First Amendment. If, however, the circumstances are so extreme that someone is going to get hurt. So for instance, say you're a racist bastard and you're just impugning blacks and saying they ought to be deported and why do they get to vote? And then you say, look at that black man, go teach him a lesson. Is that a crime? Yeah, it is, because it's foreseeable that you've whipped this crowd up into a frenzy and you've actually directed them to take a specific action. So that sort of extreme event is what Brandenburg is the line that Brandenburg draws.
What about kidnapping?
When we're talking about online advocacy, I think that's all protected speech. And I think as bad as it is, it should be protected speech. But there's also a line drawn for in terms of criminal conspiracy. So for instance, there were the Yahoos up in Michigan that were going to kidnap the governor up there. So they talked about it a lot, right? So as long as it was just talk, I say let them have their benighted, stupid theories and let them have their say, First Amendment protected. But the minute they did something like go out and purchase a weapon with the intent that they're going to use it to carry out an act, or for those individuals who cased the governor's house, and I think her like her summer home, those are what we would call acts in furtherance of a conspiracy. So the minute that you take some sort of physical act with the requisite intent, which is often extremely hard to prove, but once you actually go down you take a step down the path of realizing in the physical world the nonsense you're talking about, that would not be First Amendment protected. So there are lines to be drawn. They are always very fact specific. We don't have broad generalizations. And at least from my perspective, you have to tolerate a lot of that bad speech if you're going to have a free society. And the example, I'll just close with this, an example I often give to lay audiences is, imagine if you were an abolitionist in the Deep South prior to the Civil War, and you're advocating to free Blacks and to give them the rights that they should enjoy as human beings. In the Old South, you would be lynched for that. You would be in the ultra slim minority of people advocating that view. And the fact that it has now come to fruition and we realize these human rights and we're a better society for it, that's because of unpopular advocacy. So in terms of advancing the social dialogue, it's very important. And also, if you were just thinking about like self-preservation, allowing people with bad motives to, if you would say, blowing off a little bit of steam, that also has some social good. So you would rather have them talk about it than act on it. And to the extent that speech is an outlet for, bad thoughts, that's a good thing. And that's why we've got a First Amendment.
Great. I want to wrap this up. I want to tell you that Horace is a little under the weather. He assures us he is tested negative, so he just is not up to being here today. And so he'll have to look at a recording of this talk. I want to thank all of you for the interesting questions. And I want to thank especially our guest speaker, Attorney Gary Edinger, for his insight in lies, damn lies, and resurrection. We ask that you join us online for the next meeting of the Florida Free Speech Forum on March 8th, when our guest speaker will be Professor Elizabeth Washington, who will again bring us some thought-provoking information about how classroom teachers navigate controversial issues in contentious times, both risks and rewards. If you wish to comment on today's meeting or to offer suggestions or to help Zooming, please email us at Florida Speech Forum, no spaces there, @gmail.com. For more information about the forum, please visit our website at floridafreespeechforum.org. Be sure to tell your friends to join us next month. And we will be posting a recording of this presentation on YouTube, and we'll send out information on that as well. Thanks to all of you for joining us today, and the Florida Free Speech Forum is now adjourned. Thanks.
Thank you, everybody.